Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers, where I challenge you to replace a tenth of an hour of billing with a tenth of an hour of learning. Today's lecture is geared more towards private wealth professionals, but this is the second part of our discussion on a recent tax court case, Howard Moore versus Commissioner. Now, when we left off last time, we looked at Mr. Moore's estate plan, which involved a family partnership and several trusts that were done, in the last, couple of months of Mr. Moore's life, and how that short time frame and Mr. Moore's use of the farm caused the farm, even after being sold to an outside third party, to be included in his gross estate. So we analyzed that sale to a third party last time and found that the IRS largely ignored it because they looked at it from the perspective of, at the time that he created the partnership, he had retained control over the farm, and even after the farm had been sold, he'd retained control over the proceeds of the farm. And the important part was that control wasn't on paper, it was just in practice, the way that he treated the farm and the way he treated those proceeds and so on and so forth. But an interesting question comes up here that usually there's only that retained control argument in a case where there's a gift and not a bona fide sale. And when you create a partnership, what you're doing is you're putting property into the partnership in exchange for an interest. So it seems like that would be less of a gift and more of an exchange. However, in this case, what we found is that the IRS also ignored a bona fide sale to a family limited partnership. And we're going to look at a little bit more why it turned out that way in this case, along with other cases that have recently come down the pike dealing with family limited partnerships. So, just to reiterate again, typically you contribute capital to a partnership and receive back a partnership interest. Now, when the parties or partners in a partnership are not related, usually they're less likely to give each other a sweetheart deal. Usually the only way that the IRS can really attack a partnership between unrelated parties is by looking at how income and loss are allocated between partnership interests using the substantial economic effect test. That's a completely different esoteric argument here. Really what we're concerned with is when families have a limited partnership, they're more likely to make a sweetheart deal with each other where maybe you can have one partner who is over contributing, giving more assets to the partnership than the value of the partnership interest that they get back, and maybe you have under contributing partners who are getting a greater partnership interest than the value of what they've put into the partnership. And that tends to be a gift tax argument, but it reared its ugly head here too in terms of tearing apart the ability for Mr. Moore's estate to claim a bona fide sale. So what happened is Mr. Moore had put 4/5 of his farm into a living trust and then contributed that farm from the living trust to the family limited partnership. And since the living trust was revocable or amendable, essentially for tax purposes, Mr. Moore is treated as if he owned that 4/5 of the farm individually. Now the IRS also had a backup argument waiting in case their bona fide sale argument failed with the partnership, where they could claim that his living trust's sale of a family limited partnership interest to an irrevocable trust for $5.3 million, which was a substantial discount, might not be a bona fide sale either. Now, unfortunately, the IRS didn't get to their backup argument because that would have been a huge, boon for estate planners to figure out how not to do things. So, in this case, we really have to dig into what happens when you analyze a bona fide sale in the family limited partnership context. And what the IRS noted and the tax court noted is that typically there's two requirements in any bona fide sale. One, it has to be bona fide, which turns on the motive, and it has to be for adequate consideration, which turns on value. Now, adequate consideration and value goes back to my over contribution versus under contribution illustration earlier, which is typically the bare analysis you have have, but in a family limited partnership, the IRS takes it a step further and first digs into the motive. And in looking at the motive, the IRS requires you to have a legitimate and significant non-tax reason for creating a family limited partnership. And what happened in Moore is that the IRS claimed and the tax court agreed that there was no legitimate non-tax reason to create this partnership. Now, there are lots of positions put forth on paper as to why the partnership was created, but what the tax court found is that those paper positions didn't align with reality. One, there was a claim that the family limited partnership was designed to create unity in the family and bring them together to manage the farm, but since the farm was sold shortly after the partnership was created, that kind of drove a stake through that argument, because all they're doing essentially is investing assets through an investment advisor and not necessarily managing an active business. Now, the family also argued that the partnership was created to protect against creditor risks, but first of all, the tax court noted that while creditor risk and asset protection is a legitimate reason for creating a partnership, it's not a significant non-tax reason for doing so. So you usually have to have creditor protection plus something else. And in this case, there were some vague risks cited, like liability for the use of DDT, which practically applied to all farms in the area, and the potential for the poisoning of farm workers relating to chemical spills in the river valley where the farm was. But there were no actual threatened claims against the partnership. Now that raises its own question too, that if you wait until there's an actual threatened claim to create a partnership, you could have a fraudulent transfer. And this is the one piece of the opinion I don't agree with. It's almost like the tax court is implying that you have to wait until there's a potential fraudulent transfer issue to create a partnership in order to avoid this non-tax issue that comes up with the motive of creating the partnership itself. But shifting gears, it's important too that Moore's family actually didn't participate. Mr. Moore on paper had no control, but in reality, economically, he did exercise control over the partnership, over the farm, and over the proceeds. And his children just went along and did what they were told instead of getting their own independent counsel to review the partnership and what their roles and duties might have been. So the big key takeaways here, as always, as we've seen in many cases like this and Powell and some others, is that don't create family limited partnerships when you believe death is imminent, because it's going to be hard in that case to get around the argument that you're only doing it for tax purposes. And importantly here, Mr. Moore specifically told his attorney that he wanted to save millions in taxes in creating his estate plan and this partnership. And the partnership, lo and behold, was created within 4 days of his release from the hospital. So the circumstances and bad facts really supported that there wasn't a significant non-tax reason for creating this partnership here. And you have to substantiate the significant and legitimate non-tax reasons. Treat the partnership as a partnership, treat it how it's written on paper, have the family members negotiate and participate like they're independent business people at arm's length at all stages in the creation and conduct of active business in the partnership, and avoid retained control by the family member who's significantly funding the family limited partnership. Then finally, it's important to note that because this failed on the motive, the tax court really didn't cover the value, but it's important to make sure that the value of the partnership interest equals the value of the contributed property. Now, there's a lot of arguments that go into that in terms of discounting and everything and lack of control, but those are well covered in other cases, and the tax court didn't really cover them here because they didn't have to. So thanks again, everybody, for tuning in for this episode of The 10th of an Hour. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thanks again, and I look forward to seeing you in the next episode.